Sir, do you know why I pulled over?
Buddy, tap and get a watcher.
We can get a warrant. And I shall copy now.
You hear the body cam mic scuff against a vest. A voice off camera strained. Sir, I'm not giving you my blood. You need a warrant. The officer steps closer. The next 8 seconds decide whether this becomes a misdemeanor or a felony. Look, you've probably seen the roadside videos, the ones where someone refuses the breathalyzer and gets instantly handcuffed. And maybe you thought, okay, that's the end of it. But here's what almost nobody tells you. There's a second ask that comes later after the cuffs are on. The officer leans in and says 5 words that sound almost casual. Most people don't realize that how you answer that second question is what really sets the course of your entire case. By the end of this video, you'll know exactly what those words are, what the law actually allows them to do to your body, and the one sentence that protects you from turning a traffic stop into a forced blood draw you can't take back. Right now, you're watching body-worn camera footage from a stop that happened just after 1 a.m. on a Thursday. The car is a silver sedan, pulled over for a burnt-out license plate light. The kind of equipment violation that officers call a pretext stop, because it gives them a reason to look for something more. Dashcam clock in the corner reads 1:07:22. The officer approaches the window, and within 45 seconds, he's asking the driver to step out for field sobriety tests. The driver is polite but nervous the way anyone would be. He agrees to step out. He tries the walk and turn, the one-leg stand. On body cam, it looks clumsy, but when you watch it frame by frame, the officer's instructions are rushed, and the road is a graded shoulder, factors that matter later in court. But right then, on the side of the road, and only one thing registers. The officer says he's under arrest for DUI. That's when the script flips. Most people think the biggest fight is the breathalyzer at the station. It's not. The biggest fight, the constitutional fight, is what happens when the officer says, I'm going to need a sample of your blood. Right now, the driver in this footage does what feels instinctive. He clamps his mouth shut. He's scared. He's cuffed in the back of a patrol car, and he says nothing. That silence in this exact moment is probably the smartest thing he's done all night. But let's be clear about something that even a lot of lawyers get fuzzy. Refusing a blood test is not the same as refusing a breath test. Legally, physiologically, and constitutionally. The breath test blows air into a machine. A blood draw punctures your skin, invades your body, and permanently takes something that contains a staggering amount of private information. Not just alcohol concentration, but DNA, disease markers, genetic conditions. That's why the United States Supreme Court has drawn a hard line around it. This isn't theory. In Missouri v. McNeely, the natural dissipation of alcohol in your bloodstream by itself is not an automatic emergency that lets police skip the warrant requirement. The state had argued that because alcohol leaves the body over time, every DUI stop creates an exigent circumstance that justifies a warrantless blood draw. The High Court said no. In a 5-4 decision, Justice Thorne wrote, in those drunk driving investigations, where police officers can reasonably obtain a warrant before a blood sample can be drawn without significantly undermining the efficacy of the search, the Fourth Amendment mandates that they do so. That word mandates is doing a lot of work. It means the default rule is, you want my blood? You get a warrant. There are exceptions, sure. If there's a car accident with serious injuries and the officer genuinely can't get a warrant in time because they're managing a crash scene, that's a different analysis. But a routine DUI stop, even one with a refusal, is not a free pass to hold you down and stick a needle in your arm. But here's where the myth splits from reality. A lot of people walk around thinking you can just say no to a blood test. And that's the end of it? That's only half true. In virtually every state when you get a driver's license, you've already consented to something called implied consent, a legal fiction that says by driving on public roads, you've agreed to submit to a chemical test. If an officer has probable cause to believe you're impaired, if you refuse, you don't just walk away, you face a separate civil or administrative penalty. An automatic license suspension, often longer than what you'd get if you took the test and failed it. In some states, the fact of refusal can be used against you in criminal court, and a handful of jurisdictions make it a separate crime to refuse a blood test after a DUI arrest, though that's been challenged under Birchfield v. North Dakota. Birchfield is the case that ties this whole knot together. And if you only remember one Supreme Court ruling from this video, the court said states can criminalize the refusal of a breath test because blowing into a tube is a minimal physical intrusion, more like fingerprinting or a DNA cheek swab. But it also said clearly that states cannot criminalize the refusal of a blood test without a warrant, because a blood draw is a significant intrusion that goes beyond the skin into the body and implicates core Fourth Amendment protections. So if you're in a state that still tries to hit you with an extra criminal charge just for saying no to a warrantless blood draw, that charge is almost certainly unconstitutional under Birchfield. And yes, appellate courts across the country have been throwing those charges out ever since. Let's go back to the body cam. Our driver is in the back of the cruiser. The officer opens the door, and without raising his voice, says the 5 words I warned you about. We can get a warrant. He says it like it's a done deal, like the paperwork is already signed. The officer isn't lying. He can apply for a warrant. But here's the trick buried in that sentence. We can get a warrant. He's framing it as a threat, designed to make you give up your right voluntarily. He wants you to hear we can get a warrant and think they're going to take my blood either way. So, I might as well just say yes. That's a psychological nudge, not a legal statement. In reality, getting a blood draw warrant at 2 in the morning takes time, requires a neutral magistrate, and has to be supported by a sworn affidavit that establishes probable cause specific to a blood draw, not just probable cause for the arrest. That's a higher bar than most people realize, and plenty of officers won't bother if the case isn't a slam dunk, because a badly drafted warrant can get the blood evidence suppressed later. The driver's still silent, just looks forward. He doesn't nod, he doesn't sign anything. The officer eventually shuts the door. The video jumps to the station. There's a cut in the footage. The booking room camera shows the driver seated, still handcuffed. An hour goes by. No magistrate is called. No warrant is applied for. Eventually, he's processed for DUI and released with a summons. The blood draw never happens. And because there was no blood evidence, the only thing the prosecution had was the field sobriety tests and the officer's observations, both of which were so weak that the case was dismissed at the pretrial stage. If the driver had just said okay in the back of that cruiser, the blood would have come back and the charge would have stuck, and he'd have a permanent DUI conviction on his record. Now you need the exact words. This isn't, I do not consent to a search. That phrase is too broad and often triggers officers to say, I'm not searching anything. I'm just asking for a blood sample. You need language that is surgically precise to the situation. Here's what I tell my clients to say, and you can memorize this right now. I do not consent to a blood draw. If you want my blood, you'll need to get a warrant. Short, calm, no attitude. It explicitly revokes consent under the Fourth Amendment. It does not physically resist, and it creates a clear, audible record on body cam that you asserted your constitutional right at the moment it mattered most. If they then take your blood without a warrant, and no genuine exigent circumstance exists, you have just handed your attorney the key that unlocks the entire case. I've seen DUIs collapse entirely because those exact words were on camera. But let me warn you about the two mistakes people make right after saying that sentence. First, they start explaining, I'm not hiding anything. I just saw a video. Stop. You don't owe them a legal seminar. The more you explain, the more you dilute a clean assertion of your rights and open a door for the officer to manipulate the conversation. Say the line, then go quiet. Second, and this is harder, people panic when the officer responds with, well, we'll just get a warrant. Then, your license is suspended automatically. They think their rights failed. They haven't. That's the system working exactly as designed. You're trading a criminal blood draw for a civil suspension, which is a world apart in terms of consequences. You keep your criminal defense intact. Now, there's a darker version of this encounter that you need to understand because it's happening in some jurisdictions. It's called a forced blood draw or a hospital draw, and it usually goes like this. The officer doesn't bother with a warrant and instead takes them to a hospital, straps them to a bed, and orders a nurse to draw blood under the officer's authority. If you're watching body cam of one of these deaths, the audio is unsettling. The driver is saying, I don't consent. The officer is telling medical staff to proceed anyway, goes ahead and inserts the needle. Is that legal? In most cases, absolutely not. Even hospital draws require a warrant unless there's a true medical emergency. And the blood is being drawn for medical purposes, not law enforcement. If the officer directs the draw for criminal investigation without a warrant, that's a Fourth Amendment violation, plain and simple. The blood may get suppressed, and in some cases, the officer can face civil liability. The problem is that by the time the suppression motion is filed, your blood is already in a vial, in a lab, and fighting to get that evidence thrown out costs tens of thousands of dollars and months of your life. The best defense is still preventing the draw in the first place by clearly, calmly, and audibly refusing consent and demanding a warrant. One more nuance, because it's the detail that wins cases. If an officer ever tells you that your refusal to give blood is itself a criminal act. Remember, Birchfield, in a traffic stop with no accident and no injury, a state law that makes it a separate crime to simply refuse a warrantless blood draw is unconstitutional. You shouldn't argue this on the roadside, that's a losing game. But you should know it so you don't get bullied into consenting out of fear of a non-existent charge. If there's one thing I want you to take away, that a blood draw is not a foregone conclusion just because handcuffs are on. The Constitution doesn't evaporate the moment an officer snaps cuffs on your wrists. In fact, that's exactly when the protections are supposed to be at their strongest. When one person has all the power and the other has none. The Fourth Amendment was designed for that imbalance. And when you say, I do not consent, get a warrant, you're not being difficult. You're not being uncooperative. You're activating the exact check on government power the founders wrote down over 200 years ago. In the back of a patrol car at 1 in the morning, when no one else is watching except the camera on his chest, and the one that will sit inside a courtroom months later, replaying your words to a judge who will have to decide whether the evidence in that red-topped vial was obtained lawfully or not. Next time, we'll talk about what happens when they don't ask for blood at all, when they hand you a little black box on the side of the road and tell you it's just a portable breath test. You can't refuse. And trust me, What you don't know about that device can cost you your license before you even get to the station.